Our next speaker is Professor Neil Cohen, who is speaking to us here from New York. Professor Cohen is Professor of Law at Brooklyn Law School, where he teaches domestic and international commercial law, contracts law, and conflicts of law. Professor Cohen served as report for the revised Article 1 of the UCC and for the ALI's restatement of the law of suretyship. He's a director of the UCC Permanent Editorial Board. He served as a member of the 2010 UNIDROIT Principles Working Group. Professor Cohen will provide us with an overview of some new topics addressed in the 2010 principles, and in particular under the rubric of Plurality of Obligors. Neil.
Thank you, and good afternoon. I'm aware that I'm the only person standing between people in 2 continents and 5 locations and the rest of their day, so I'm going to try to stay within my allotted time. As Richard and Joachim have mentioned, that the 2010 edition of the UNIDROIT Principles, in addition to refining some of the existing principles, added coverage of several new topics, and one of the topics, and the one we're going to focus on now, is multiplicity of obligors or obligees. I think both were covered for reasons of logic, completeness, and symmetry, but we're going to focus on only one of those 2, and that's the one where most of the interesting legal issues are, and that is when there are multiple obligors for the same obligation. It's quite a large set of rules about that, and I'm going to focus just very briefly on 7 of them, and we'll take a look at those 7 principles. And the first one, which should be on your screen now, is Article 11.1.2. This deals with an issue that, of course, parties can deal with in their own contracts. The principles in Article 11, and like many contract law principles, are default rules. They deal with the fact that most contracts are incomplete, that people don't negotiate everything out, but if parties want a different result than this, of course, they can. And the key here, of course, as you can see from the provision that's on your screen, is that the rule we have here is a presumption. If you have multiple obligors for the same obligation, the presumption is joint and several liability, that the obligee can recover the whole amount from any one of the obligors, and of course performance by one discharges the others, because the obligee is only entitled to one performance. It's important to note in this regard that you can have multiple obligors for the same obligation, either because they are all incurring it together because they're all getting a benefit from the obligee's performance, or, as is very common in common law jurisdictions in particular, this can be a mechanism to get the credit of one person to stand behind something that would otherwise be the obligation of another, and that invokes concepts of suretyship and guarantee law. The principles themselves do not address the principles that come in when we do have a suretyship or guarantee situation, and comment 3 to Article 11.1.2 makes this point, but I'll mention it a few more times along the way. The basics of joint and several liability are fairly obvious. Again, the creditor, the obligee, can recover from any of the parties, can recover the whole amount from any of the parties, and it's left to them to sort things out. It's a very pro-obligee situation, which is what most obligees want and would like in such a situation. Obviously, payment by one of the obligors discharges the others to the extent of payment, because the obligee is entitled to only one satisfaction. Article 11.1.6, however, deals with another type of satisfaction. It points out that if one of the obligors is released, that discharges the other obligors for the share that was released, and so they're only liable for the remainder. It's a perfectly common sense situation, because they have benefited from that release just as they would have benefited from payment by the obligor, and so they get the benefit of that release, and so does the obligor get the benefit of that release, because that contributed to the benefit to the others. And so we have payment or release working out the same way. 11.1.8, which deals with the effect of a judgment against one or more, but not all, of the multiple obligors, is pretty interesting because we learned two things in Article 11.1.8. First of all, that the other obligors, those who are not parties to the judgment, aren't bound by it, but they can rely on it. This is sort of heads I win, tails you lose, because if they don't like what happened in litigation to which they were not a party, they're not bound by the result. But if they like it, they get to assert that result if there was a defense. In a sense, they get the best of both worlds. Now, in a number of jurisdictions, including the U.S., which I know best in this regard, there's a procedure that will often be used in those situations called vouching in, where the party who is a defendant in a lawsuit from whom payment is sought and will want to recover from the others later will say to the others, I don't want you to come up with great ideas later that I didn't know about and then raise them as defenses against me. So come on into this litigation and defend, or otherwise you will be bound by the results here and bringing about a different result in 11.1.8. And parties might want to think about negotiating for some sort of a vouching in procedure like that. So the first obligor doesn't get whipsawed between litigation that comes out one way to which that person is a party, and then defenses raised by the other co-obligors in later litigation. Well, what if one of the obligors pays the whole amount? Well, that's what the person signed up for, right? Joint and several liability means the obligee can recover all of the claim from any one of the obligors. Well, that's only part of what that obligor signed up for. The obligor knew that it would be liable for the entire amount to the obligee, but didn't sign up for being solely responsible as among all of the obligors. And so Article 11.1.9 talks about how the multiple obligors, the co-obligors, allocate the responsibility among themselves. The key, of course, is they really ought to agree, but it's very common for them not to agree. Since it's very common for parties not to think about this, we're given a presumption in 11.1.9, which is that they are bound in equal shares. They can agree to the contrary, but notice that 11.1.9 also gives the court or arbitral tribunal the right to conclude that circumstances indicate otherwise. So if they are all co-owners of an enterprise but in different shares, that might lead to that their proportion of liability should equal to their shares the enterprise, or if it's a loan and they got different amounts of money from the pot, that might be circumstances that would similarly contribute to different amounts of liability as among the co-obligors. But the presumption is equality. One unusual situation that can come up, or actually not that unusual, but it doesn't come up unless one of them is really a surety or guarantor. Sometimes, if one person is the real borrower, for example, on a credit transaction, and a second person agrees to be jointly and severally liable to add that person's credit to it, they are co-obligors as far as the obligee is concerned, but really, as between themselves, the implicit or explicit agreement is one of them should pay all of it, and the guarantor really shouldn't be responsible for any of it. And so that's something to keep in mind as well in looking at the allocation parties under this provision. Just very briefly, three others. 11.1.10 is the other side of the coin from joint and several liability. It is that if you are the one who is caught in the joint and several liability, it makes the point that, of course, you can recover from the others to the extent that you pay beyond your contributed share. And really, that ought to go with the very first provision. 11.1.11 is a very interesting provision because it says that if you are someone who paid more than your share. You're the obligor from whom the obligee recovered money, and now you want to recover from the other obligors. Paragraph 1 here says that you get to exercise the rights of the obligee, including all rights securing the performance of the obligors as part of collecting from the other obligors. It's like subrogation in the U.S. context. You get to go after collateral that the obligee has or other supporting obligations like letters of credit or the like. It's a very helpful thing. Now, in common law countries, typically you wouldn't get that right unless the obligee claim completely satisfied. So you wouldn't be in competition with the obligee. The principles here do it slightly differently. You get this right from the beginning, from the first dollar you paid, but to the extent the obligee hasn't been paid yet, paragraph 2 subordinates the co-obligor who's trying to recover from the others to the obligee's rights to use that collateral. Finally, just one last one, 11.1.12, defenses that you can raise when you're being asked to pay your contributory share. It's pretty obvious what they would be. The most interesting one is paragraph A, that the obligor can raise any defense that could have been raised, any defense that was common to all of them that could have been raised. That makes sense. If the person who paid initially didn't raise the defense, well, you would have raised the defense, so why should you suffer from the fact that that person didn't? But it also gives the possibility of a little bit of gotcha here, because if you know the defense, but you didn't tell the first one who paid about it, then that person pays without knowledge of it, and then you come back and say, well, I don't have to pay you my share because that defense was there. This is another good reason to think about contracting for sort of a vouching in procedure, where if you're the one who is asked to pay first, you get to say to the others, participate in the defense or be bound by the result. Well, this is just a survey of what's in the chapter on multiple obligors and obligees. Again, it's just enough time to scratch the surface, but I think these are the basic provisions.
Thank you, Neil. The principles are pretty impressive in terms of the level of detail that plurality of obligors and obligees has developed. Hopefully people will take a look at those after having heard this brief overview.
But thank you all for attending. It's been a pleasure.